Hello.
Hello, ma'am.
So, counsel, did you have a chance to confer with the state?
Yes, sir.
All right.
Today, but previously we did. There is a plea bargain offer.
All right, so was an offer tendered today or no?
Previous, at the last setting.
All right, so are you asking for a jury trial?
No, ma'am.
Then what are we doing?
Can we come back tomorrow at 10 o'clock? She needs to drop off her child at school and she could be here there in this.
All right, Ms. Ferguson, recall this tomorrow for disposition, please. And put it at 10 a.m.
Thank you, Judge.
Thank you,
Thank
ma'am.
you.
Appreciate it.
You're welcome. Just wait till you receive the reset form. Yes. Paul Carpenter.
Yeah, I'm pressing on that.
All right. So, yes, where are we on discovery?
Your Honor, I conferred with the state as far as this PG1 less than a gram, we were fine on discovery. But it's my understanding that he has at least one sealed burglary of a habitation and another burglary of a habitation pending. We're asking, in discussions with the state, we're asking for time to put a global offer together. Although our client does not want that. He wants some sort of offer on that one case, even though these other cases are pending. And he's told us that he doesn't want us on the case at all.
Okay.
So that's what we're doing with Your Honor.
All right.
I'm trying to get this taken care of, Your Honor.
Well, you have two burglaries of a habitation that your attorney hasn't had a chance to review.
My attorneys haven't even came to speak to me.
All right.
They don't show up to no meetings.
Let me ask you something. Did you speak with your attorney today?
This is not my attorney.
I am standing in for Rochelle.
Yes. So have you spoken to him?
Not about everything, no.
All right, Ms. Ferguson. Recall this for tomorrow.
And I'm asking for a new attorney, or I mean, I wonder
I
what's
believe
going on.
Rochelle has done visits and was informed he didn't want her on the case, and we have filed motions to withdraw it.
Oh, no, here's the thing. That's your attorney. If you,
County courts, well, they were gonna give me a new attorney because they weren't showing up when I was in the world, and she wasn't showing up to none of my court dates.
all right, I don't have anything to do with county court at number 12.
Okay.
This is the 187 district court.
Yes, ma'am.
So I'm recalling your case for tomorrow and your attorney will be here.
Okay, then.
All right, thank you.
Thank you.
All right, the court is calling 2025 CR 0057770 State versus Christopher Consalato. All right, can I have the parties announced for the record?
Jason Garahan for the state, Your Honor.
Lauren Lupton for Mr. Consalato.
And are you Mr. Consalato?
Yes, Judge.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, this is an application. Did you review the application for community
Yes, Judge.
supervision with your attorney? Did you understand it? Counsel, did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand the true bill of indictment?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
All right, you're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Consalato, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes,
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $500 fine. State recommends community supervision. They're taking in consideration 2025 CC 011039. There's to be restitution of 6,700. Did y'all agree to the restitution?
We did not, and if you see, it says restitution hearing to be
All right.
determined.
So there's to be a restitution hearing. Did you understand that to be the plea?
yes, Judge.
And you understand that the most it appears that the state will be asking for is $6,709.70.
Yes, Judge.
Defense, is that the plea?
That is the plea.
State, is that the plea?
That is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with the complainant. Well, yes, no contact with the complainant in the MRT program. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
yes,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest, I believe.
State, any evidence?
Yes, Your Honor. State Exhibit number 1 with all this attachment.
No objection, Your Honor.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes,
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We asked you follow the agreement, Your Honor.
All right, how old are you?
Judge Boyd, I'm 53.
Why are you throwing rocks at somebody's vehicle, like Ernest T. Bass? Why are you doing that?
Disrespectful to my mom. I know I shouldn't be doing it, but it's
Wait a minute, was this your mother's vehicle?
no.
All right, so what about the disrespect to the complainant? Why are you,
I know.
yes, why is he throwing rocks?
So unfortunately, the complainant is the defendant in the case against his mother. So
They're neighbors, Your Honor.
they're neighbors and unfortunately, it's just a complicated neighbor situation.
I mean, it's calmed down now.
Right, he understands
And I
that
don't-
there should be no contact and no communications. And he's committed to being successful in that.
Well, this is not Mr. Rogers' neighborhood, is it?
No. No, I'd like to go there though, if that's an option.
No.
I'll move.
All right, is this the only offense he's ever had?
No,
What's the previous?
he does have prior history. It's not, I don't want to misrepresent anything. I do think there has been a less than a gram case
Yeah.
in the past and some other misdemeanors. And then, yeah, obviously the case is less.
And where did you find rocks?
In my yard.
Okay. All right, court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's a $500 fine that will be probated. Proof of employment within 30 days. No employment as a home health care provider or with minors. Are you currently employed?
No.
How do you support yourself?
I get this disability check, but mom mostly helps me out.
He lives with his
Yeah.
80-something-year-old mother
Yeah.
and helps care for her.
And what's the nature of your disability?
I'm looking to find a job. This is my back, I have minor back problems, but I'm looking to find something to get back to employment.
All right, so I require people work when they're here. Unless you're 100% disabled, you're going to need to find employment. You understand?
Right.
So proof of employment within 30 days, no employment as a home health care provider with minors, regular reporting by Zoom or in person, regular random UAs. There's to be 100 hours of community service restitution. I'm going to order the MRT. Once he completes that, community service hours will be deemed satisfied. Field visits 1 time per month for 6 months. There's to be no contact with the complainant. And Ms. Ferguson, can I have a restitution hearing in 30 days, please? Is that enough time for the state?
It should be, Your Honor.
So there's going to be a restitution hearing on September 18th. There is to be taken in consideration 2025 CC 011039. Probation, anything else? All right, is there anything else you need from the court to be successful?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yeah.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. With regards to his warrant, is that related to this case?
No, Your Honor, the warrant is related to the case that's being TIC'd. I don't know if the court would sign the dismissal or I need to.
No, you'll have to go to county court number 9, and then county court 9, they'll be in charge of the warrant.
Okay, will y'all take it down to 9 then after? this?
All right. All right, good luck to you.
Okay, I'll follow up. with
You
9.
better.
Judge Boyd.
All right,
Thank
you're
you.
welcome.
Will I have to, will I be released?
You'll have to take it up with county court
I'm
at
gonna
law
work
number
on it.
9.
I'm gonna get the dismissal side of it.
Did I do
All right.
You're gonna go with that, and I'll talk to your mother, okay?
it? Will they release me?
Hopefully. in the next
All right, and
while.
counsel, on your other case?
Thank you, Judge.
Oh, you're welcome. Just give me 1 second to put this in the system.
Yes, Judge.
All right, we're back on the record in 2025 CR 0089995 State versus Matthew Garcia. If I could have parties re-announce, please.
Ashley Jones for the state.
Jasmine O'Gean for Mr. Garcia.
And you, Mr. Garcia?
Yes, Your Honor.
All right, so we're going to take up your motions, one motion at a time. The first with regards to waiving or reducing of GPS monitoring fees. If you want to call your client as a witness, he'll need to prove indigency since you're retained.
Yes, Your Honor. Can I first proffer to the court the different bills that he has? Or do you want to hear it from
Any
him?
objections?
No objection to a proffer, Your Honor.
Judge, I don't want to enter this because it does have a lot of personal.
Oh, let me
information.
just review it
Okay,
and see what's.
but this is just the military information that and how much he receives.
Okay, and then what, I see the monthly amount he receives. Then what are the deductions?
Yes, Your Honor. The first deduction is going to be $1,000 for child support.
Okay,
And that is going to be garnished from his check, we believe sometime in September.
okay,
Because it was initially $300, but it is now increasing.
okay.
$1,200 for a mortgage payment, 370.
Just 1 second. So the $1,200 is for mortgage and then,
$370 for car payment,
okay,
$280 for an insurance of.
just 1 second.
Sorry.
No problem. All right, and then what comes after the car payment?
The insurance for the car, which is 208.
Okay,
And then for a phone bill, 215.
okay,
$450 for water, light, and internet,
okay.
and then about $1,000 for food.
All righty.
And that will bring us to a total judge of 4,515, which would just leave over about $140 or so.
All right.
And then I can have Mr. Garcia confirm that if you'd like, Judge.
Oh, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
You can lower your hand, state your name for the record.
Matthew Garcia.
All right, your attorney has shown me the amount you received from Veterans Affairs. Is that correct, the amount?
Yes, Your Honor.
And your attorney has told the court the different bills that you have that are deducted from that amount every month. Is that correct?
That's correct.
All right, thank you. All right, the court will grant the motion to waive the GPS fees.
Yes, Your Honor.
Now, the next thing has to do with the contact. And the person that he wants to have contact with, who is, according to this, is 14.
Yeah.
Yes,
Judge, we have amended the motion since we filed it, and now we are just requesting that instead of him allowing to have contact with the 14-year-old and for that 14-year-old to reside in the home, all we're requesting is for him to live in the home, and the 14-year-old is not going to be living there, will not be making any sort of visits, and he will not have any contact with the 14-year-old, which is not the complaining witness in this case, Judge.
okay,
And the state is in agreement with that. We have confirmed that the child will not be living or having contact with anyone in that home.
I'll say. Okay, so I don't have that amended, so I'll just write it in here
Okay, Judge, and
that.
this is also what we corrected. I don't know if you would like to write it, but thank you,
Yes.
Judge.
All right, and then the next is to allow him to attend school.
Yes, Your Honor, I believe the motion does ask for tracking, but we have agreed to partial for school purposes. My understanding is that the school schedule is not confirmed yet, so we would just ask that it be granted, but he remain on full house arrest until he provides a school schedule to pretrial services.
All right, so this is what the court will do. With regards to that motion, the court will follow the agreement and amend from full house arrest to partial for college only. And it's upon proof of enrollment in your class schedule. Is there anything else?
Yes, Your Honor, we have proof of enrollment, but he was waiting to enroll in the actual classes until the court made their ruling.
Okay,
So he just needs to provide that at pretrial.
yes.
Okay,
And if there's an issue, just let me know.
thank you for your time, Judge.
All right, you're welcome. And he already has a court date, correct?
Yes,
I
sir.
believe so, Judge.
All right, thank you.
Thank you. Have a nice day.
You too. Counsel, do you want photos of the orders? And then if you can give them back to me so I can put them in the system.
Perfect.
Oh, and let me give you this one.
Thank you, Judge.
Thank you. All right.
All right, let's talk about that. Judge Boyd's docket had quite a range, and the case of State versus Christopher Consalato stood out, because it mixed the procedural with a touch of humor, which you don't always get in a felony plea hearing. The judge was firm but approachable, guiding Mr. Consalato through every step of his no-contest plea on a charge of criminal mischief in the $25,000 to $30,000 range. What really jumped out was Judge Boyd's patience. She carefully confirmed that he understood the indictment, the plea bargain, the restitution hearing, and his waiver of rights. That's the kind of thoroughness that prevents appeal issues down the road. Her quip comparing his rock-throwing antics to Ernest T. Bass from the Andy Griffith Show lightened the mood. And she even tossed in a "this is not Mr. Rogers' neighborhood" line when the back and forth about neighbors came up. Those little touches of humor show a judge who knows when to balance gravity with humanity. Mr. Consalato himself was an interesting figure. At 53, he came across contrite, but still a little puzzled about his own behavior. When asked directly why he was throwing rocks, his answer, "disrespectful to my mom," didn't quite connect the dots. Especially since the vehicle wasn't hers. That seemed to highlight the neighbor dispute under the surface. The complainant apparently has a pending case against his mother. So tensions were already high. To his credit, he admitted he shouldn't have done it and acknowledged he needs to move forward without contact. He didn't appear evasive. More just a man caught in an ongoing feud who let his frustration boil over. The attorneys did their jobs efficiently. Defense counsel had clearly reviewed the discovery, admonishments, and plea paperwork with the defendant. The state presented the evidence in the form of reports and stipulations without drama. Nobody seemed ill-prepared. It was a professional exchange all around. When restitution came up, over $6,700, the defense correctly reserved it for a separate hearing, which is exactly how it should be handled. Both sides stayed on task, leaving Judge Boyd to keep things moving. The overall courtroom atmosphere was professional with moments of levity. Judge Boyd's humor diffused tension, but didn't distract from the seriousness of the proceeding. The final sentence, 2 years in state jail suspended for 3 years probation, a $500 fine probated. Community service, MRT program, proof of employment, and no contact with the complainant, was firm but fair. She also took care to ensure probation conditions were realistic, requiring employment unless he's fully disabled. That practical approach shows she's focused not just on punishment, but also on rehabilitation. In the end, what could have been a dry plea hearing turned into a snapshot of neighbor disputes, judicial patience, and a reminder that throwing rocks at cars is never a smart move. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.